Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Before we get to the published cases, I wanted to make everyone aware of loyal fan of the show, Abby Anna Batko-Taylor, and her team's lengthy but unpublished Fifth Circuit win in Morales-Lopez v. Garland. In their unpublished win, the Fifth Circuit held, among other things, that death threats from a Honduran gang rise to the level of past persecution, even without physical attack, and that generalized country conditions evidence will not negate the presumption of a well-founded fear. Congratulations, guys, and thanks for emailing me about the win. Feel free to do the same, my army of loyal listeners. On to the show. I know I say it every week, it seems, but there are truly wild cases this week. Enjoy. First, we have Alejos-Perez v. Garland, published by the Fifth Circuit on March 22, 2021. We're going to start off with the case because it's an interesting one, on divisibility and laws relating to controlled substance offenses. Mr. Alejos-Perez appears to be an LPR from Mexico. As relevant to this decision, he was convicted in 2018 of Texas Health and Safety Code Section 41.1161A, which prohibits a person from, quote, knowingly possessing a controlled substance listed in Penalty Group 2A, end quote. An immigration judge found, and the BIA affirmed, that the conviction made him removable as a lawful permanent resident convicted of a law relating to a controlled substance, under INA Section 237 A2BI. The Fifth Circuit reversed that removability finding. We've dealt with these offenses many times on the podcast. Here, the Texas controlled substance possession crime is broader than the generic federal definition of a controlled substance, because Texas criminalizes possession of more drugs than the feds do. So, unless the actual drug possessed is an element of the offense in Texas, the analysis is over. The Texas crime cannot relate to a controlled substance offense and make an LPR removable. But if the drugs are elements of the offense, the statute is divisible, and further analysis is therefore permitted under the modified categorical approach. Succinctly stated, in the Fifth Circuit, quote, divisibility depends on 1. The statutory text, 2. State case law, and 3. The record of conviction, end quote. Is the statute divisible? Here we go. Mr. Alejos-Perez was convicted of possessing a drug listed in Texas Penalty Group 2A, which essentially lists 8 categories of drugs at Section 41.1031B1 through B8. Somewhere within those 8 categories is, quote, at least one substance that isn't federally controlled, end quote. That makes the statute overbroad vis-a-vis the federal controlled substance removability offense. Moving on to divisibility, the Fifth Circuit held that the answer, quote, is inconclusive, end quote. And because the divisibility analysis is inconclusive in this case, the government, who had the burden to establish Mr. Alejos-Perez's removability, failed. Here's why. The Fifth Circuit first held that the statutory text of the Texas possession statute didn't answer the question. Now it recognized, as the BIA has recently in matter of dictiar, that because the text carries different punishments, the statute may be divisible. But in this statute, the different punishments varied depending on the amount of drugs possessed, not the type of drug possessed, which is what the relevant question is. Therefore, the punishments don't make the statute relevantly divisible. I discussed this concept in depth on episode 39 when the BIA did a similar thing the other way around in matter of dictiar. It would appear, therefore, that this part of the holding disagrees with some of the analysis in dictiar. Worth remembering in the Fifth. The Fifth Circuit also held that Texas case law didn't answer the question either. Now true, as the Fifth Circuit recognized, the government relied on a pretty good quote about the statute from Texas's highest appellate court that arose in the double jeopardy context. But, and remember this, quote, double jeopardy cases shed little light on divisibility because, in Texas, the double jeopardy analysis bottoms out in an examination of the factual differences between statutory alternatives, which cannot prove divisibility with the needed certainty, end quote. As to the other lower court decisions relied upon by the government, quote, mere intermediate state court opinions don't definitively resolve the issue. Presumably, the higher court could come to a different conclusion, end quote. Keep 'em coming, Fifth. Finally, turning to the indictment and jury instructions in Mr. Alejos-Perez's case itself, the Mathis Peak if you will, the Fifth Circuit held that the documents go both ways on divisibility. Quote, given that countervailing language, the record does not speak plainly on the issue of divisibility, end quote, as is required. So the case was remanded. I know it's a complicated case, and I know I went through the divisibility analysis pretty quick, but suffice to say, burdens rock. Although the Fifth Circuit did remand for Mr. Alejos-Perez to now show that Texas actually criminalizes possession of drugs not covered in the federal list, which to my understanding is not how the categorical approach is applied in any other circuit, and it doesn't really make sense to me here. But so be it. I can only imagine that listener Jordan Pollack and her cadre of Texas Padilla attorneys are celebrating. Kinda. Here's some more on the categorical approach and burdens. First, worth noting, in this case the Fifth Circuit refused to look at pattern jury instructions for the crime, as the categorical approach allows, because, quote, the pattern jury instructions for Section 41.1161 are the product of a State Bar of Texas committee, which has no authority to decide state law, end quote. Remember that argument and make it for any other state where it helps, including, of course, the Longhorn State. And finally, to me, this decision appears to present the hypothetical that I mentioned a couple of weeks ago when discussing the Pareda case from the Supreme Court. In Pareda, the majority presupposed a divisible statute, and then held that the non-citizen could not establish relief eligibility on an ambiguous factual record that does not show what crime the non-citizen was actually convicted of. But I don't read Pareda as deciding who wins at the relief stage when the record indeed reflects the actual conviction, but is ambiguous as to whether the statute is divisible. That's what happened with Mr. Alejos-Perez, albeit in the removability context. Now true, here the government had the burden because it was removability, so the question wasn't fully answered. But again, to me, whether a statute is in fact divisible should not be one where burdens matter. Rather, it should just be something that an IJ must decide. As the Fifth Circuit notes here, quote, in Mathis, the court contemplated cases in which the divisibility analysis is indeterminate, In such situations, in the context of applying a sentencing enhancement, a sentencing judge will not be able to satisfy the court's demand for certainty when determining whether a defendant was convicted of a generic offense." End quote. Such certainty seems equally important when it comes to deporting an individual as well. And that is Alejos-Perez v. Garland. Sticking with the Fifth Circuit and taking a breather on the categorical approach before we jump back in, we have Njilefac v. Garland, published by the Fifth Circuit on March 24th, 2021. This case is about a motion to reconsider related to an asylum application and affidavits. Mr. Njilefac is from Cameroon and sought asylum and removal proceedings based on his affiliation with the opposition political party in Cameroon. An immigration judge ruled against him, and he appealed through an attorney, but the attorney claimed he never received the BIA's briefing schedule and the transcript of proceedings that the BIA sends when it's time to brief an appeal. Having therefore received no brief by the due date, the BIA affirmed the IJ 3 months later. Mr. Njilefac's attorney did receive that decision. Cue every attorney's worst nightmare. Mr. Njilefac timely moved the BIA to reconsider based on due process grounds. In support, Mr. Njilefac, presumably through counsel, submitted 2 declarations, one from his attorney and another from an attorney who shared the same mailbox, stating that his attorney never received the relevant documents from the BIA. The 2 attorney declarations were signed under penalty of perjury, but did not represent that the statements were, quote, true and correct, end quote. Cue every attorney's second worst nightmare. Also, that second attorney, the one who shared the mailbox, qualified his affidavit by stating that everything in the affidavit was, quote, to my knowledge, end quote. The BIA denied the motion to reconsider, holding that Mr. Njilefac had not overcome the presumption of delivery, and that the affidavits weren't actually sworn affidavits at all. The Fifth Circuit affirmed under the deferential abuse of discretion standard it applies to such motions. It noted the general presumption that mail reaches its destination, meaning that Mr. Njilefac had a high burden to succeed. He did not meet it here according to the Fifth Circuit. The briefing schedule was not returned to the BIA as undeliverable, and the attorney received the IJ's decision and the BIA's decision at the same address that he claimed he did not receive the briefing schedule at. Moreover, the declarations, quote, stated only that the counsel had not received the relevant documents, which is typically insufficient to cast doubt on a delivery, especially where, as here, our review is highly deferential, and especially since it is not clear that staff did not receive the relevant documents, end quote. This, in addition to the fact that the affidavits were not sworn to, permitted the BIA to give them less weight, and perhaps, as the Fifth Circuit posits in a footnote, disregard them entirely. The Fifth Circuit therefore upheld the BIA. Here's a bit more on the wild world of affidavits. Excuse me if I've now become a bit paranoid. Following this decision, in addition to getting the language perfect in an affidavit, it would appear that affidavits of non-delivery must account for every possible contingency, including here Mr. Njilefac's argument on petition that, quote, the documents could have been part of a batch of mail that had been scattered on the side of the road, end quote. The Fifth Circuit would have an affidavit account for that too, in order to even consider it. And it would appear that every staff member in an office or every household member must submit a sworn affidavit to have a chance of succeeding, at least following this decision. Personally, and this is just me, I copy and paste verbatim the language of 28 U.S.C. section 1746 every time I draft an affidavit. I will continue to do so. And that is Njilefac v. Garland. Next, we have Lopez-Chavez v. Garland, published by the 8th Circuit on March 22, 2021. Hold on to your horses if you got 'em, because this is a crazy case about aggravated felonies. And based on what I saw on Facebook, the non-citizen was represented by my friend and colleague from San Diego, Andrew Nietor. Less crazy and very competent. Mr. Lopez-Chavez is from Mexico. He became a lawful permanent resident in 1990 through, it appears, President Reagan's Special Agricultural Worker, or SAW, program. He was convicted of Missouri possession of marijuana with intent to deliver in 2003, and he was charged as removable as an LPR convicted of an aggravated felony, to wit, INA Section 101A43B, an illicit trafficking in a controlled substance aggravated felony. He was found removable and he was physically removed to Mexico in 2003 based on the drug conviction. But he re-entered illegally shortly thereafter, and in 2006 he pled guilty to illegal re-entry in violation of 8 U.S.C. Section 1326, receiving a 3-year prison sentence. After serving the sentence, it appears, the 2003 order was reinstated and he was removed again. He then attempted to unlawfully re-enter again in 2009, and he was caught, and he pled guilty to illegal entry in violation of Section 1325. After a short imprisonment, the 2003 order was reinstated again, and he was removed again. Then, in 2010, he was caught trying to re-enter again. This time, he was charged with both federal crimes, Section 1325 and 1326. But this time, through new counsel, he moved to collaterally challenge the 2003 removal order, as is allowed in such proceedings. Because if that first removal order was unlawful, you can't have a federal conviction for illegal re-entry after removal. A federal district court judge denied the challenge, but the Ninth Circuit reversed in a published decision in 2014, United States v. Lopez-Chavez. In that decision, quote, the court determined that Lopez-Chavez received ineffective assistance of counsel throughout the 2003 removal proceedings, which prevented him from reasonably presenting his case, prejudiced him, and rendered the proceedings fundamentally unfair, end quote. But that doesn't actually get rid of the removal order. So Mr. Lopez-Chavez used that decision to file a motion to reopen his 2003 removal order with the immigration court that issued it, which the immigration judge granted, meaning that Mr. Lopez-Chavez returned to LPR status after all those years, and despite those prior convictions and imprisonments for illegal re-entry. The law is a strange thing. In reopened proceedings, DHS amended its removal charge, now charging Mr. Lopez-Chavez under the same statute charged in the Fifth Circuit case that we just discussed, INA Section 237A2BI. As an LPR convicted of a law relating to a controlled substance, which quite frankly DHS probably should have charged from the start in 2003. This removal charge was sustained, but as Mr. Lopez-Chavez had now technically held uninterrupted LPR status since 1990, and an immigration judge just reopened his case implicitly holding that the conviction did not match an illicit trafficking aggravated felony, he applied for LPR cancellation of removal under INA Section 240A. But an IJ and the BIA then denied that relief, finding that his 2006 illegal re-entry in violation of 8 U.S.C. Section 1326 qualifies as a different aggravated felony, INA Section 101A43O. That's important because aggravated felonies preclude a non-citizen from obtaining LPR cancellation of removal. And finally, folks, 6 minutes in, we come to the legal issue at hand. The Eighth Circuit held that the IJ was wrong in so finding, and that the BIA was wrong in affirming. Now, candidly, this is actually not an aggravated felony provision that I've ever reviewed. INA Section 101A43O doesn't come up that much, and it defines as an aggravated felony, quote, an offense described in Section 1325A or 1326 of this title committed by an alien who was previously deported on the basis of a conviction for an offense described in another subparagraph of this paragraph, end quote. Now, Mr. Lopez-Chavez definitely has the 1326 conviction, and for that matter, a 1325 conviction. But was it on the basis of a conviction for an offense described in the aggravated felony statute? That's the question. Turns out the issue doesn't come up often anywhere. Oyl argued here that no further analysis was required, because in 2006, Mr. Lopez-Chavez pled guilty not just to Section 1326 illegal reentry, but to Section 1326 for, quote, illegal reentry into the United States subsequent to an aggravated felony conviction, end quote. So, according to Oyl, his conviction already entails the second portion of the statute, that the illegal reentry follow an aggravated felony conviction. End of story, so said the government. But the Eighth Circuit disagreed. It held that, quote, a court applying Section 101A43O must determine 1. Whether the non-citizen has committed an offense under Section 1325A or Section 1326. 2. Whether the non-citizen committed that offense after having been previously deported. And 3. Whether the previous deportation was on the basis of a conviction for an aggravated felony listed in Section 101A43, end quote. And that third element, the underlying aggravated felony element, isn't satisfied merely by the plea or a conviction. It requires a separate analysis by the IJ about whether the conviction underlying a removal order that serves as the basis for the 1326 conviction was in fact an aggravated felony. By the way, requiring that analysis and not simply relying on the conviction creates a circuit split with the Fifth Circuit on what's required of Section 101A43O. It gets crazier. In the Eighth Circuit, the question therefore becomes, was Mr. Lopez-Chavez's 2003 Missouri marijuana conviction an aggravated felony under INA Section 101A43B? Again, it was at the time of his removal in 2003. But by the time of his final removal hearing in the reopened proceedings a decade later, it was not. That's because by that time, the Supreme Court had issued Moncrieffe v. Holder, addressing the same illicit trafficking aggravated felony provision and a very similar marijuana possession conviction, albeit from Georgia. In Missouri with Mr. Lopez-Chavez's conviction, as in Georgia with Mr. Moncrieffe's, the marijuana possession with intent to deliver statute of conviction criminalizes delivery of only a small amount of marijuana for no pay. And such a criminal statute is not an aggravated felony under Moncrieffe. Oyl doubled down, arguing that it doesn't matter what Moncrieffe held. It only matters whether the conviction was an aggravated felony at the time of the removal in 2003. Or at least at the time of the illegal reentry in 2006. Not so, said the Eighth Circuit. Quote, the INA unambiguously anchors the inquiry in the text as it is written and understood at the time of that inquiry, end quote, i.e., at the time of that last removal hearing. And that finding may create a circuit split with the 3rd, 7th, and 9th Circuits. A bit unclear, but I'll still give it a gong. So Mr. Lopez-Chavez gets to apply for discretionary LPR cancellation of removal. Congratulations, Androniator, on the fantastic and very hard-fought win. My God. One more thing on Moncrieffe. Excellent Moncrieffe analysis here if it helps your case. Oyl argued that the Eighth Circuit couldn't do what it did because the approach, quote, improperly applies Moncrieffe retroactively, end quote. After all, his conviction and even the first removal proceedings all happened before Moncrieffe was issued. The Eighth Circuit didn't bite, holding that Moncrieffe and other decisions like it constitute, quote, an authoritative statement of what the statute meant before as well as after the decision of the case giving rise to that construction, end quote. Put another way, Moncrieffe clarified what Section 101A43B, quote, always meant, end quote. It just took 20 years to get there. It's not retroactivity, it's correcting an erroneous statutory interpretation. and that is Lopez-Chavez v. Garland. Are we having fun yet? Sticking with the Eighth Circuit, we have Gutierrez-Gutierrez v. Garland, published on March 22, 2021. This decision is about reinstatement and motions to reopen. Mr. Gutierrez-Gutierrez is from Mexico and entered the U.S. in 1996 with a 3-day border crossing card, but he stayed until 1998. The former Immigration and Nationality Service instituted removal proceedings, and Mr. Gutierrez-Gutierrez, with counsel, appeared in a court in Kansas City for his removal hearing, with a judge appearing via televideo from Chicago. Mr. Gutierrez-Gutierrez accepted a removal order, and with the televideo judge's permission, the INS attorney signed the judge's name and served the order on Mr. Gutierrez-Gutierrez. He was removed in April 1998, and he re-entered a month later with the border crossing card again, which was illegal for him to do. He was caught in 2018, and DHS reinstated the 1998 removal order. Mr. Gutierrez-Gutierrez then petitioned the Eighth Circuit for review of that reinstated order, and simultaneously he filed a motion to reopen of the 1998 order with an immigration judge. As the basis for that motion, he argued that he suffered ineffective assistance of counsel in 1998. The IJ and the BIA held that they lacked jurisdiction to address the motion to reopen because DHS had already reinstated the removal order, and so it all went up to the Eighth Circuit. Now, INA Section 241A5 holds that a reinstated removal order, quote, is not subject to being reopened or reviewed, end quote. But most circuit courts, including the Eighth, have held that they have jurisdiction to review whether reinstatement was proper, and other constitutional questions and questions of law relating to the removal order. And here, the Eighth Circuit upheld DHS's reinstatement. To satisfy the reinstatement regulations, DHS must simply establish, quote, 1. A prior order of removal, 2. A subsequent departure from the United States under that order, and 3. An illegal reentry, end quote. Mr. Gutierrez-Gutierrez argued that the first prong wasn't met because it was, quote, a forged non-order signed by the government attorney rather than a removal order signed by the immigration judge, end quote. But the record shows that the IJ did sign a removal order. He just served Mr. Gutierrez-Gutierrez with a copy signed by the government attorney. Mr. Gutierrez-Gutierrez also argued that his reentry wasn't illegal because in actuality he was inspected and admitted within the meaning of matter of Quilantan when he re-entered with the border crossing card. The Eighth Circuit held that yes, while Quilantan does stand for the proposition that a fraudulent or unlawful entry like Mr. Gutierrez-Gutierrez's can serve as an inspection and admission for adjustment of status purposes, quote, the relevant question here is whether Mr. Gutierrez-Gutierrez re-entered lawfully, not whether he was admitted, end quote. The Eighth Circuit found that while procedurally regular, the re-entry was unlawful, and thus allowed for reinstatement. With the removal order properly reinstated, the Eighth Circuit concluded that the IJ and the BIA properly held that they lacked jurisdiction to review the motion to reopen of the 1998 removal order. Although the BIA at one time in the 1960s allowed non-citizens like Mr. Gutierrez-Gutierrez to file such motions to reopen, the law has since changed to include the reinstatement bar, and that bar does not have a, quote, gross miscarriage of justice exception, end quote. Interesting, though. Compare this decision to the Vega-Aguiano v. Barr decision, published by the Ninth Circuit and discussed on episode 31 of the podcast, where the Ninth Circuit did seem to hold that a gross miscarriage of justice may indeed prevent a final order of removal from being reinstated. Perhaps the way to square that Ninth Circuit decision with this Eighth Circuit decision is that the gross miscarriage of justice exception is something that only the circuits, and not the immigration judge or the BIA, can consider. Something to think about. and that is Gutierrez-Gutierrez v. Garland. Finally, we have Acevedo v. Garland, published by the Ninth Circuit on March 24, 2021. This is a case about particular social groups. Mr. Acevedo was a 32-year-old man from El Salvador. His father was killed by guerrillas during the armed conflict in El Salvador in the 1990s, and he entered the U.S. to be with his mother in the early 2000s. He began to exhibit symptoms of a mental health disorder, and it got him into some minor criminal trouble in the U.S., but no convictions. However, having come to the attention of DHS, he was placed in removal proceedings. An IJ found him not competent to represent himself and appointed a qualified attorney to represent him. Thank you to the ACLU and the Franco v. Holder litigation. And of course, its implementation nationwide by some very thoughtful Assistant Chief Immigration Judges. The IJ's competency finding was based in part on a psychologist's report estimating Mr. Acevedo's intellectual functioning as equivalent to a 7-year-old child, and his academic skill development at a kindergarten level, and that he appeared to be experiencing hallucinations. Through counsel, he asserted a fear of return to El Salvador based on his membership in the particular social groups, quote, Salvadoran men with intellectual disabilities who exhibit erratic behavior, or in the alternative, indigenous El Salvadoran men lacking familial support, suffering from severe mental disabilities, and exhibiting bizarre behavior, end quote. He presented expert and documentary evidence to support his claims. An immigration judge and the BIA denied, finding that the first particular social group was not cognizable under immigration law. But neither the IJ nor the BIA reached the second particular social group, finding it materially similar to the first. The Ninth Circuit vacated and remanded. First, it disagreed with the BIA's particularity analysis. It held that as Mr. Acevedo was specifically diagnosed with a, quote, intellectual disability, end quote, as that term is understood by psychologists, it is sufficiently narrow and defined. Indeed, there's a whole handbook called the DSM used by psychologists to define the term. Although an IJ is, quote, not required to accede to expert opinions, she was not entitled to disregard the terms of the psychologist's diagnosis, end quote. Nor does it matter whether the average layperson can identify an individual with an intellectual disability, or that there are many types of subdiagnoses. The term intellectual disability, at least when based on medical diagnoses, is sufficiently defined by clear benchmarks, making it particular. As to social distinction, the Ninth Circuit held that the BIA erred in two ways. First, it erred by holding that the intellectually disabled in El Salvador are not distinct from the, quote, larger population of mentally ill individuals, end quote. And that's an error, because social distinction asks whether a group is recognized by society in general, quote, not whether the group is sufficiently distinguishable from other similarly persecuted groups, end quote. Again, it's not overly relevant that Mr. Acevedo's group might be subsumed into a larger group. What's relevant is, quote, whether individuals with intellectual disabilities are singled out for greater persecution than the general population, end quote. Second, the BIA erred in disregarding the various evidence of how those exhibiting mental health disabilities are treated, because, quote, evidence of harassment and discrimination is an important factor, end quote, to consider in the social distinction analysis. Finally, both the BIA and the IJ erred in failing to address the second particular social group, quote, indigent El Salvadoran men lacking familial support, suffering from severe mental disabilities, and exhibiting erratic behavior, end quote. And that's error, because, quote, IJs and the BIA are not free to ignore arguments raised by a party, end quote. Plus, the Ninth Circuit seems to believe this second particular social group potentially cognizable. The Ninth Circuit did, however, affirm denial of Convention Against Torture protection, relying heavily on similar analysis in the Mexican mental health context from its decision 13 years ago in Villegas v. Mukasey. The record of how El Salvador treats individuals like Mr. Acevedo doesn't compel a contrary conclusion. So, the case was sent back for further particular social group analysis. Congratulations Kiran A. Para-Moreno and Jared Renteria, certified law students, and their supervising counsel, Evangeline G. Abril, of Santa Clara University School of Law. Great to see law students getting great wins, especially for particularly deserving clients, and with great quotes to boot. And that is Acevedo v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.